For some 3 centuries, ever since the first European settlement of North America, the land has been seen as a vast and incomparably rich treasure waiting to be put to use. Indeed, the notion that it was underutilized by the indigenous people served as a central justification for the settlers to displace them. Transformation was seen not only as an opportunity, but as a kind of mission. To the settlers, the wilderness was a challenge and an obstacle, wild in the sense that it was to be tamed rather than embraced for what it was. And it is a fair description of events to say the transformation is exactly what happened unceasingly from the 17th century until the latter part of the 19th century and well into the 20th, when the first refuges and parks were set aside and what we now think of as the stirrings of the first conservation movement. All this history is, of course, very familiar to you. As we now think about the world that has been left to us in the light of contemporary problems, such as deforestation and the role of forests in sequestering greenhouse gases, the systematic destruction of salmon streams up and down the Pacific coast, the spectacular loss of wetlands everywhere, or the extraordinary worldwide decline in biodiversity that has been described so eloquently by E.O. Wilson, one has to wonder how our predecessors thought about what they were doing. Since my own lifetime extends well back before the dawn of the contemporary environmental era, which I date to about 1962, when Rachel Carson published Silent Spring, I clearly recall the uncontrolled and visible pollution of the rivers and the choking smokestack output of the steel mills in the industrial Midwest where I grew up. All this seemed normal and hardly worthy of remark, to say nothing of outrage, to my parents and their contemporaries. Of course, there were a few prophets out there, people like Aldo Leopold and Bob Marshall in the 1920s and 1930s, but their work hardly touched the lives or thoughts of the vast majority of Americans at that time. So I've puzzled a good deal about what most folks were thinking back then and why the great majority of sensible and intelligent people seemed oblivious to things that seem so obvious to most of us now and that have proven so costly and difficult to get right. Some differences are well known and have been much discussed. At one time, the continent seemed so vast as to be inexhaustible, though that surely cannot have been an illusion that persisted into the 20th century or even into much of the 19th. A more significant factor was doubtless a deep faith in technological progress, which of course is not an illusion, and which is strongly fortified by our can-do attitude and our optimistic faith that there are solutions for just about every problem if only we work at it hard enough. Technology has served us very well, and it will continue to do so, notably in areas like sustainable energy. But that faith has also led us down some dead ends. In addition, we overestimated the significance of the role that would be played by lands set aside as natural reserves, as I shall spell out shortly. However, there's another dimension to the difficulty we face in coming to terms with our historic assault on natural systems and the challenges we face in achieving sustainability. It has to do with how we conceive of the land we hold in private ownership. I think it's fair to say that for people generally, the meaning of land ownership embraces 2 basic ideas. A political one focused on privacy and autonomy, and an ethical and economic one based on the right to the product of one's labor and effort. The privacy autonomy idea is captured in the old proverb, famously quoted by the 16th century jurist Edward Coke, that one's home is his castle. While we generally think of privacy in the sense of a refuge from state intrusiveness, it also bears powerfully on the way we use and think about our right to use land. For it conjures up the image of a place that is unqualifiedly our own. That aspect of ownership embraces the idea of autonomy, that your land is yours to do with as you wish, so long as you do not use it to harm or intrude on other people's rights by trespass or air pollution, for example. Now, one may think of this as the self-determination version of the privacy concept. So long as you operate within your own boundaries and without creating what are now called negative externalities, you should be free of state coercion or obligation. Of course, there is a much deeper and more contentious side to this aspect of ownership. Vagueness about what the term harm should include. Our definition of harm defines how and where we draw the line between what ought to be in the individual's private realm and what is the business of the public. There are many commonplace examples that test the line between what we consider an issue for the autonomous individual or for the community to decide. Is it harmful to tear down a historic building you own? Should the community be allowed to require architectural review of what you can build? Or keep you from growing tall trees that block your neighbor's view of the mountains or the ocean? Should you be prevented from blocking sunlight and thus your neighbor's access to solar power? Our reactions to these and similar issues tell us what we think property rights consist of, and in a more profound sense, what we consider a proper relationship between the community and the individuals within it. The general notion we carry around in our heads about what we ought to be able to do as owners, that is, what's our business because it isn't doing harm, is in fact a way of describing the community's sense of what's important and what constitutes legitimate or illegitimate control of private autonomy. That agenda can descend to matters as small as control over the color a house is painted and as consequential as a decision to industrialize. The foundation of America's agenda was built on the vision of our European forebears about the destiny of the New World. That vision was distinctly not summed up in the phrase, "We belong to the land, it doesn't belong to us." However appealing a notion that may be, it describes a conception of land drawn from a culture and a way of life profoundly different from that which shaped this land. And it has never reflected the reality of land use here over the past several centuries. On the contrary, the dominant idea of the European settlement was that the continent was indeed waiting to be made ours, as human labor was mixed with it. The expression virgin land was not an idle metaphor. The notion that the earth was capable of being made fruitful, but was not yet so, and only awaited husbandry, was a metaphor rich not only in imagery, but in meaning for the settlers. The land was not empty, and it was not barren, but it needed to be impregnated with human labor to be transformed and thereby to fulfill its destiny. Transformed from what to what? The wilderness was a natural world, full of birds and animals and forests and prairies and wild rivers. Far from being empty, it was simply not space devoted to the uses thought most desirable and productive by the settlers. It did not lack an economy, but it provided what might be called an economy of nature. That economy was what the world produced without human intervention. While it was abundant and productive in the sense that the skies were teeming with birds, the rivers with fish, and the forests with wild animals, its product was not what the settlers wanted. Indeed, it was to a very substantial degree an obstacle to what they wanted. It produced forests and prairies where they wanted cropland, and it produced wolves and bears where they wanted sheep and cattle. That's why they talked of taming the wilderness, and that's exactly what they did. They embarked upon a transformative process to create an agricultural and ultimately an urban and industrial economy that relied very little on the economy of nature. Forests were cut to make farmland, prairies cleared for houses and stock raising, wetlands filled to make croplands, land fenced and wildlife displaced to be replaced by cattle, rivers, mill sites, and so on. While the natural economy was not totally extirpated, to the extent that it remained, it was because it was not, or not yet, in the way of the new economy. The idea that it was desirable and could be compatible with a developmental economy to retain some natural features like wetlands and wildlife corridors was not, and to a substantial extent still is not, the way people saw things. For 2 centuries, virtually nothing of the economy of nature was intentionally saved. That is well known. What is perhaps not so well recognized, though it has been extensively documented by legal historians, is that the law was constructed and reconstructed to drive this process forward. The rules of land ownership were shaped in order to incentivize transformation to the new economy and to discourage retention of nature's economy. For example, there was no legal or economic reason to leave water in a river or to refrain from damming it, nor was there any such reason to leave land unfenced so as to permit the passage of wildlife, or to leave land uncultivated as habitat. On the contrary, leaving water in a river was considered waste. Even those who wanted to obtain a right to keep water flowing instream were prevented from doing so. The old industrial rules mandating retention of the natural flows of rivers were abolished so that rivers could be dammed to generate hydropower. The open range was fenced, and bounties were paid to exterminate predators such as wolves. That was the logic of the transformative economy. And the law of property was its obedient and malleable servant. The law of property did not protect old rights and existing practices, as many people believe. It changed, often dramatically, to accommodate and incentivize the new transforming and then industrializing economy. The loss of natural services engendered by this system was magnified by another reality of the time: the use and move on system. The familiar theory that ownership promotes sustainability because proprietors have a self-interest in maintaining sustainable production on their land is surely true in general, but was undercut in several important respects. The ready availability of new and richer land diminished the incentive to maintain a given tract when there were rich opportunities beyond the existing frontier, first in as yet unexploited domestic regions and later in foreign lands. A similar phenomenon operated as to lands rich in non-renewable resources. There was no incentive to think about sustaining supplies for the long term, since there was always new mineral-rich land elsewhere. The experience of Western mining lands is illustrative. Miners usually didn't bother to take ownership of the lands they staked under the mining law, though federal mining law allowed them to do so at a nominal cost. Instead, they put down their claims, mined out the site, commonly leaving the surface in nearby streams contaminated, and then abandoned them, only to move on to Alaska or Bolivia or Australia or wherever. To the extent that loss of natural values was recognized, the dominant response was not the disdain for industrialization that Thoreau spoke of in Walden, saying, "We do not ride upon the railroad, it rides upon us." Instead, there was an optimistic faith that through the marvels of technology, we could have it all. The classic example was the establishment of fish hatcheries to compensate for the loss of salmon streams, and the construction of flood control dam and reservoir projects to replace floodplains. A companion idea was a conception of nature as something that could be saved and set aside in parks and refuges, while the ordinary work of society went along as usual on the rest of the landscape. Though the limits of each of those approaches is well known today, they were doubtless ideas much easier to embrace in an era that understood less than we do today about how natural systems actually work. The fish hatchery offers the classic example of reconceiving the economy of nature in terms of the developmental economy. A river is seen as a salmon factory, and the hatchery is established as a more industrially efficient way to produce fish. Salmon, as many as we wanted, could be produced in hatcheries, but water for irrigation was scarce and precious. Today, the decision to destroy salmon streams for reclamation projects seems not only naive, but in light of the many, many millions that are to be spent restoring the damage they did, economically reckless as well. The floodplain story is well known, and I will not reiterate it in detail here. Dams and reservoirs were built to retain floodwaters so that the lands that previously absorbed those waters could be put to what was thought productive use. These lands fill with houses and other structures, but larger floods have inevitably come, and the taxpayers literally and fiscally bail out the owners, fulfilling the prophetic observation of the great geographer Gilbert White, who more than 60 years ago demonstrated that every dollar spent on flood control structures generated multiple dollars in subsequent flood damage. The Katrina disaster is only the latest and most widely known example of the problem. Today, with the prospect of warming and earlier snowmelt that will increase spring flows, we're beginning to see yet another value in maintaining floodplains in undeveloped condition as an economical way to capture and hold those flows as an alternative to building new storage facilities. The set-aside of nature in parks and reserves is another story of excessive can-do optimism with a happier but still highly imperfect ending. Though Wallace Stegner himself said the national parks were, quote, the best idea we ever had, they were basically established for their scenic qualities, and as far as wildlife is concerned, they were long largely managed as outdoor zoos. They were set aside with little concern for what we today understand as natural system management. Glacier National Park, which you heard mentioned earlier, has its western boundary in the middle of a river and its northern boundary at a line marking the Canadian border. Its southern boundary is set at a railroad track, and an Indian reservation borders it on the east. The Flathead River that bounds Glacier on the west has its headwaters in Canada, where it has been vulnerable to mining and energy extraction, though to its credit, the British Columbia government has recently declared it off limits and plans to buy out mineral interests. So Glacier, magnificent as it is quite unsuited to be managed for the wildlife population it only partially contains. And until quite recently, the national forests that abut it and are integral elements of its habitat were essentially managed as production centers for maximum timber harvesting and for potential oil and gas exploration. Nor is Glacier exceptional in this regard. The Everglades, which you may have read about in the papers just the other day, the Everglades provides another vivid example of a place unhinged from its natural setting, located as it is at the downstream terminus of a complex riverine system that provides the water that defines it. Yet that system was diked and dammed and diverted to promote sugar plantations and to serve urban growth. Only in recent years have efforts been begun to restore the Everglades as an integral tropical land, water, and wildlife system. Now, to be sure, both the national parks and other set-aside public lands like the refuges and the multiple-use BLM lands and forests and national forests, despite their limitations, have proven ecologically valuable simply because they represent large and generally less developed lands compared to the acreages in private ownership. Some of the parks like Yellowstone are large enough to be ecologically significant, even though they're not sufficient as habitat for their wildlife. The refuge system is also exceptional, though it's hardly ample. It was created precisely because it was habitat, established initially for the protection of migratory waterfowl, and it was for the most part less committed to visitation than the parks. An even more striking point about insufficiency may be made about the wilderness. It has been said with some justice that the wilderness ethic is based on the assumption that the relationship between humans and nature is a zero-sum game, a place where any sign of human intervention constitutes a contamination. From this perspective, the set-aside of wilderness areas can be seen as a sort of museumization of nature, a confession that modern society is engaged in a systematic destruction of the natural world. Of course, that's the very antithesis of the idea that we should use our land and water sustainably to minimize the loss of biodiversity and to maintain, and where feasible, restore functioning natural services. Notwithstanding the great contemporary benefits of our various set-asides of land as parks, refuges, and so forth, we now understand their distinct limits and inadequacies from the perspective of a land managed for sustenance and sustainability. The lesson is simply that functioning natural systems cannot be marked off as distinct protected enclaves while business as usual goes on heedlessly everywhere else. To the extent we want the benefits of natural services, to slow the decline of biodiversity, to benefit from the role of forests in controlling warming, to rely on seashore dunes to protect uplands, and to facilitate renewable energies like solar, the role played by those services has to be accounted for on land everywhere, including the great majority of the land which is held in private ownership. To do that calls for a different way of thinking about what ownership entails. I began by observing that we think of land as fully private and privatizable space. That is, so long as an owner does not impose harm elsewhere, what he does internally is no one's affair but his own. Crudely stated, he can't be bad, but he doesn't have to be good. But this view assumes that there is no legitimate societal interest in what goes on internally within one's private boundaries, even when it's kept within those boundaries. Thus, to take what has seemed a legally clear, but uneasy case, an owner's entitled to chop down a tree on his property, even if it's the world's most ancient redwood. That is the conventional way of conceiving land. But now let's look at land as habitat, as the constituent of biodiversity. Who owns biodiversity? It's not a question our legal system is structured to ask. I suppose the answer is everybody and nobody. One way of thinking about it is as an unprotected common superimposed on privately owned land. We can all agree it's a good thing and deserves as much protection as we can manage to provide it. We can also agree that its protection depends on the maintenance of adequate, viable habitat, and that the habitat consists primarily of land in private ownership. So we find ourselves in unfamiliar territory. There's something very important to us all collectively, but we don't own it. It inheres in and depends on something called habitat, which is also unowned. Habitat inheres in land, which is owned, and which we have always believed owners could generally use as they wished, which largely involved destroying its value as habitat. However, we believed that they could use it as they wish because we thought what they did with it wasn't, or at least shouldn't be, anybody else's business. And we've believed that posture was important to the maintenance of privacy, individualism, liberty, and autonomy. But it turns out that maintaining biodiversity is very much our business. So it seems that the public has a legitimate stake in the way in which owners use their land, even though the owner isn't doing anything that has traditionally been thought of as outside his private domain and therefore is unpermitted. Moreover, the usual arguments for meeting public needs by means of paid public acquisition don't seem to apply to this problem, simply because of the massiveness and pervasiveness of the issue. The public, if it were to buy up the needed habitat value of all the land that is appropriate to control loss of biodiversity, would have to buy up so much that the whole notion of public compensation of owners, the notion being that a small number should not have to bear the cost of something that ought to be everybody's responsibility, would be swallowed up by the pervasiveness of the enterprise, a massive circular distribution of money that would require a massive public tax. From a fiscal perspective, we would essentially be back where we began. The problem isn't really about money. It's about what that potent phrase, my land, really means in the 21st century. My own conclusion is that understanding the nature of sustenance and biodiversity calls for a rethinking of our assumption about land ownership and a review of the notion that what owners do with their property, assuming they are not conventionally harming others, is nobody's business but their own. One striking way to illustrate how the traditional view of ownership operates and why it does not work as it should is provided by the Endangered Species Act. That law effectively makes it illegal for a landowner to harm listed species found on his land. The result is that those owners whose land provides habitat for a species determined to be in jeopardy are subject to restrictions on use, sometimes quite severe restrictions, that are necessary to maintain their land as viable habitat. What singles out an owner for such restrictive regulation of use is, of course, that his land still has value as habitat. If he had previously developed the land so as to destroy its habitat value, he would bear no such responsibility. From the perspective of fairness, there could hardly be a more dramatic example of no good deed going unpunished. Only those who have not already destroyed the habitat value of their land bear the burden of the law. Now, why is the burden left to be borne by the few who have not yet destroyed their land as habitat? Simply because landowners in general bear no obligation to manage their land so as to maintain its value as habitat. That sort of positive obligation to the community has generally been considered an intrusion on an owner's prerogatives. Our laws rarely incentivize shaping development so that habitat values are maintained as much as possible, consistent with the needs of human communities. While obviously some habitat for wolves or grizzly bears, for example, cannot coexist with most human settlements, many biologically desirable land use practices, such as leaving more open space, clustering development, retaining more wildlife corridors, not bulldozing streams, setting development back from wetlands and floodplains and coastal dunes, are among a panoply of common practices more sensitive to maintaining habitat. Some such limitations are called for by laws. All are controversial and are routinely challenged as at odds with property rights. Yet implementation of the sort of limitations they embody would have made unnecessary many of the rigorous last-ditch measures that we have seen under the ESA, and would have avoided the unfairness issues raised by burdening only those who have not yet extirpated natural processes on their land. Managing land with more sensitivity to the maintenance of natural services need not be onerous and can be compatible with other goals that are now increasingly recognized as desirable. There's now a substantial literature on the subject. And just to give you one little charming, old-fashioned example of a less destructive land use, this example appears in Ed Wilson's wonderful autobiographical book, Naturalist. He's describing how, as a youngster enchanted by bugs, reptiles, and amphibians, he spent many productive afternoons at a local goldfish hatchery in the Florida Panhandle, where the fish were sold for bait, operated by a local man named Mr. Perry. This place, though it was a remunerative business, was the antithesis of an industrial bulldoze and build facility. Wilson explains that Perry's water came from artesian wells, and he fed his goldfish with cornmeal from a local and pig's blood from a local slaughterhouse. This is what he says. Perry had excavated the ponds, but thick weeds choked their borders and tall trees walled them in on the swamp side. The whole ensemble was a textbook diagram from an ecology textbook made literal. The rich nutrients pumped in continuously gave birth to an exuberance of algae, aquatic plants, and fish. The net produce of biomass fed swarms of insects, frogs, snakes, herons, and all the waste draining into the exit streams fructified the biota of a deep swamp. Water snakes abounded, feeding on schools of blood-gorged fish and armies of frogs. This is a biologist's autobiography. Mr. Perry made no attempt to control them. They were, he said, no more than a minor source of goldfish mortality. Although neither of us had the vocabulary to express such things, we shared the concept of a balanced ecosystem, one in which man could add and take out energy, but otherwise leave alone without ill consequence. Mr. Perry was a natural-born environmentalist. he trod lightly upon the land in his care. Just as land has not often been dealt with in the Mr. Perry model, the same can be said of water in the West, and the same can be said about our treatment of wetlands. The conclusion from all these experiences is that we simply don't know how to think about habitat value and about the way a given tract of privately owned land relates to viable wildfowl populations, to say nothing of global climate change. The sort of last-ditch rescue efforts that the ESA embodies reveal not only a failure to protect important natural values before they become critically jeopardized, but an inability to link even those efforts to an equitable treatment of landowners. Thinking about habitat as I have described it here should evolve an image of land with values that pertain not simply to individuals, but to communities as a whole. Values whose scope accords with the way we think about our historic heritage, or public health, or education as community values. Yet almost every conception of land in modern times has ignored community in favor of images of privacy and personal identity. The enclosure of the commons in Europe, the fencing of the open range in America, the division of the country into squares of 640-acre sections, all these acts embody the idea with which I began these remarks of open land as essentially unused or underused and awaiting human labor to make them productive. And they also reflect a decline in the notion of things we hold in common. When those few foresighted people like John Wesley Powell, whose biographer was Stegner, pointed out how ill-suited conventional land arrangements were to the arid West, even that very limited recognition of land as part of a natural system was quickly and thoroughly rejected. One might make a similar point about water arrangements that were focused on the community and not just the individual, like Pueblo rights that got minimal recognition in a few Western states, but that never got a foothold within the profoundly individualized and piecemeal approach to water rights that has long dominated every state in the West. All these decisions and changes were based on the idea, sometimes explicit and sometimes implicit, that what benefits the individual owner also benefits the general public, both in terms of product and in incentives for long-term sustenance. Increasingly, certain criticisms that are commonly heard today, such as the absence of any provision for future generations, which is one element of the sustainability debate, miss an important point. The problem isn't that future generations have no representatives to speak for them. No one really thinks the future should be ignored. Consider how people think about their children and their grandchildren, or talk about the fiscal responsibility of government to future generations. The telling point is that we have assumed that current patterns of ownership would necessarily take care of the future, both by the incentives of owners to care for their land and by the capacity of technology and innovation to deal with problems like exhaustible resources. While neither of those assumptions is wrong in toto, as I indicated above, both have proven insufficient as we've learned more about the economy of nature and seen the inadequacy of the present system to protect it and us. Of course, we now have many laws and regulations that limit the full autonomy of owners. But the underlying assumption continues to be that they're only justified insofar as they prevent conventional harm to others, anti-pollution laws and zoning laws that limit density in order to prevent congestion. The one notable exception in favor of a kind of community entitlement has been the long-standing recognition of the need to protect the viability of huntable wildfowl by applying closed season rules to hunting on private lands, and by the general understanding that birds nesting in our trees are not trespassers. But as I indicated above, as laws have moved beyond conventional notions of harm prevention, they've been systematically challenged, and often successfully, as trenching on the rights of owners. The intense controversy engendered by the Endangered Species Act, when it is applied to govern the use of private land, is indicative of how uneasily that law fits with conventional notions of ownership. So we're still very far from seeing land as part of the natural economy, and until we get beyond that mental, legal block, we will not be able effectively to come to terms with a plethora of interests that are now discussed under the broad mantle of sustainability. Thank you.